Hi, folks. This is Mike Foster. Welcome to our town hall meeting on Syngenta GMO corn litigation. I've been an attorney for 40 years, and I'm licensed in Indiana, Illinois, Iowa, and Nebraska. I'm a solo practitioner in estate planning, which I love, and you may have seen my ads in the farm world for estate planning seminars. My practice is particularly focused at farm planning and helping families save their family farm. I have come up with a particular type of living trust design and a particular type of LLC design and a particular type of trust for heirs that uniquely preserves the family farm through the costs of from the costs of death and from elder care and its costs, and provides continuation of the farm to children involved in farming while treating those non-involved heirs equally and fairly. When I'm not doing Syngenta presentations or town hall meetings, I'm usually advising 1 to 3 farmers minimum per business day. I had farm clients come to me asking me about the Syngenta GMO corn litigation back in March of 2015. I found out Syngenta is a $32 billion international seed company that can crush an opposing solo practitioner like a mosquito on your pickup windshield. The case against Syngenta is not about their GMO corn itself, which we think is pretty great stuff, but it's about the manner in which Syngenta introduced that GMO corn into the commodities market, which began and started the collapse of that corn market when the corn market had achieved a historic high, and they achieved that collapse by driving off the largest purchaser of U.S. corn, which was China. In order to give my inquiring clients the best advice, I learned that I needed to refer them to a team of law firms with individual respective focus in different areas rather than any one particular firm. And here's not only what I found out, but I'm now recommending to anybody who was a corn producer. Syngenta is an international seed company of about $32 billion in capital assets. It was formed from 2 very large international pharmaceutical companies who spun off their agrochemical divisions into a single Swiss company for the purpose of developing and selling seed grains around the world. But to sell seed grain globally, they needed to sell seed grain in the United States, the world's largest and greatest producer of corn. The U.S. produces 6 times more corn than any other nation on earth. Syngenta had no infrastructure for marketing grain in the United States, so they purchased 2 well-known companies, Garst and Golden Harvest, which did have a complete infrastructure for marketing seed. Syngenta then totally absorbed those 2 companies, so that all that's left of those 2 companies today is just the trade names alone. Syngenta then spent $200 million from 2000 to 2006 to develop a genetically modified protein stack within the corn that, when eaten by 16 above-ground pests, would stop up their digestive system such that they died without reproduction. This protein stack was called MIR162, and Syngenta labeled the seed corn Viptera. From 2006 through 2007, they developed a further variation of MIR162 that would also kill corn rootworm, a below-ground pest, as well as the 16 above-ground pests they called that seed corn Duracane. Syngenta obtained a 20-year patent on Viptera in June of 2006, which gave them exclusive rights to market this seed corn until June of 2026. They also obtained a 20-year patent on Duracade in 2008 as well. They obtained USDA approval to market the corn not only as seed corn but also as a pesticide. From 2007 through 2009, they obtained approval of Viptera as a seed corn for foreign nation import from the U.S. And it obtained that approval in Japan, Canada, Mexico, South Korea, in the European Common Market. The problem for Syngenta was China, who was buying their foreign corn exclusively from the United States at that time. They had just begun to import corn, and they imported all their corn from the United States. But China had a no-tolerance policy regarding the importing of GMO grains prior to approval of those GMO grains by the Chinese Department of Agriculture. And the Chinese Department of Agriculture was notorious for taking 2 to 4 years to obtain approval of GMO grains. This case is not about the quality of Viptera or Duracade as GMO corn, nor is it about GMO grains in general, which we think are a very good development. It's about how Syngenta brought about the collapse of corn prices within the U.S. commodities market when corn was selling at a historic all-time high, by directly causing the loss of China as an available market to the U.S. corn, and thus lowering the demand on the same supply and causing an oversupply that drive the market down.
Please look in your packet and find the piece of paper that is a white on green timeline, identical to what I've put up on the screen. This timeline records the events that happened regarding Viptera. You'll see that we start with a patent for MIR 162 in June of 2006, which is a 20-year patent that ends on the other end of the timeline in June of 2026. Then we show the approval of Viptera by foreign importers, and some of the information I've already just provided you in our introduction. And then we show that in 2010, Viptera announced to release Viptera to the U.S. corn producers in the 2011-2012 growing season. The National Grain and Feed Association and the North American Feed and Grain Association published warnings to Syngenta that premature release of Viptera without approval of MIR 162 by the Chinese could cost the U.S. corn producers that exclusive market, which in turn would cause collapse of the corn market from its all-time high of $8.25 a bushel. Syngenta paid no heed and proceeded to release Viptera to 12,000 U.S. corn farmers without any restrictions on the sale of corn or any isolation requirements to prevent cross-pollination. And what happened is that as the 2012 harvest was purchased by elevators, Viptera was mixed in with all the other U.S. corn. Plus, there was cross-pollination such that the entire grain supply was contaminated with MIR 162 protein trait staff. All the elevators bought Viptera except Bunge Elevators. Bunge put up signs saying, "We will not buy Syngenta corn." In 2013, Syngenta had the arrogance to sue in federal district court Bunge Elevators for defamation of character for the signs that were posted. In November of 2013, Cargill had accumulated vast amounts of U.S. corn and loaded 576,000 tons of U.S. corn, enough to feed China for a full year, into a ship and sent that ship to a Chinese port. The Chinese Department of Agriculture took a sample of the hold in that ship of the corn, and it tested to the presence of MIR 162, an unapproved GMO. The Chinese rejected not only the load, but all further corn from the United States from being imported into China. Cargill ship then had to travel around the world looking for a place to dump a year's worth of Chinese corn, and the oversupply started the downturn in the corn market. At the same time, the ethanol industry was buying corn at an all-time high of $8.25 a bushel, which was putting some stress on the industry. But they could cook the alcohol out of the corn and dry and grind the remaining mash into a distillate called DDG, which was bought only by China at that time to feed their livestock. But MIR 162 was found in the DDG as well, and China prohibited all further import of DDG as well. The lack of this price support to the high cost of corn per bushel for the ethanol industry created some economic stress. They lost the DDG offset to the cost of corn, and without that offset, the ethanol industry began to collapse as well as companies were going bankrupt. The collapse of the ethanol industry led to the collapse of the soybean prices. So the whole thing started to cascade down. The economic director of the National Grain and Feed Association, the economist Max Fisher, published a 28-page report stating that Cargill's loss of its corn sale, which caused that ship to sail around the world with an oversupply of corn, caused a loss to the corn producers. The loss of the Chinese demand caused the first 11 to 50 cent drop in the prices of corn and represented about a $1 to $3 billion loss to U.S. corn producers. You can find Max Fisher's 28-page report on the website Syngenta-lawsuit, www.syngenta-lawsuit.com. It's a very intricate, detailed report. Our economists are estimating that the complete loss to the farmers from just the actions of Syngenta with respect to China on the falling corn market was about $1 per bushel per year for the years 2013 and the years 2014. In addition, if farmers were holding over harvest from 2012 and didn't sell it till after that November of 2013, there would be a drop in prices and therefore a loss to them on that harvest as well. Meanwhile, back in federal district court where Syngenta sued Bunge Elevator, Bunge filed for summary dismissal in early 2014 on the grounds that the Syngenta created Viptura and therefore had complete control of its registration and licensing. There had been prior precedent for seed companies being responsible for their marketing techniques causing collapse of commodity prices because of the failure to obtain proper licensure of the GMO grain. Syngenta had been warned of the injury that they were going to cause to the corn market by these two grain organizations, but marketed Viptura in direct disregard for those injuries. Syngenta countered in this lawsuit with the argument that the collapse of the corn market was unpredictable and unforeseeable, and that the Chinese actions and reactions were also totally unpredictable, such that Syngenta could not be held responsible for the loss of corn prices. In the summer of 2014, that court agreed with Bunge, holding that the case by Syngenta should be dismissed because the injuries were fully foreseeable by Syngenta, and Syngenta had full control of the necessary registration and only control of that registration to prevent those injuries and refused to take those precautions. Syngenta was fully liable for those injuries. If you have full control of your sheep gate, and you leave the gate open such that the wolf sneaks in and eats all your sheep, you cannot blame the wolf for being a wolf. And Syngenta, in full control of registration of Viptura, cannot blame China for being China. The case was dismissed. In October of 2014, first Cargill and then ADM brought suit against Syngenta for the damages to their corn commodities market. The court soon appointed a federal master referee, a sitting federal district court judge in Kansas City, Missouri, for the purpose of deciding motions and other disputes in the case against Syngenta, but not for the purpose of trying the actual lawsuits that developed. In December of 2014, China finally approved MIR 162 for sale in China. But it was speculated that they approved GMO because Syngenta had so globally marketed Viptura that all the corn was contaminated with the protein stack throughout the world. And if China wanted any kind of corn to import, Viptura was going to be in all of it, and they had to approve the GMO. China also resumed import of the DDG at that time. It was speculated that the damages of Syngenta would stop with Chinese approval of Viptura because they'd resume buying U.S. corn. But in April of 2015, China bought 600,000 tons of corn from the Ukraine and Australia, even though that corn from those ports to the Chinese port cost China more per bushel than U.S. corn to those same ports. The Peking Times reported that no U.S. corn was bought because of continued government fear that Duracade had contaminated the U.S. market without Chinese approval, just like Viptura had previously contaminated that same U.S. corn market. So it now looks like the U.S. corn production for 2015 will be an includable damage as well, even though the corn harvest is not yet been harvested.
Now please find the other green and white piece of paper in your packet of information, and let's take a look at it. It should be similar to what's now on the screen. Here we're illustrating that the average direct loss what it will be to the average U.S. farmer. According to the United States Department of Agriculture, the average corn farmer tills 704 tillable acres, and that yields an average of 171 bushels per acre for a total yield of about 120,400 bushels per year. If we take that amount times Max Fisher's estimated initial direct loss to corn farmers, they had an immediate direct loss of about $13,250 to about $60,200 per year if we round those numbers up. If their loss if they had this loss for 2013, 2014, and now 2015, the direct market loss would be about $40,000 to about $180,000. They may not be able to buy another 80 acres or a new combine with that kind of money, but they may be able to pay for a year or two of college for one of their children. This is a common loss to all farmers that is certainly too much to simply ignore. But at $1 per acre, the amount would be about $80,000 to $360,000, which is becoming quite significant. And if you have more acres to farm or more in corn production, that number will only get larger. But this next slide helps us determine that Syngenta's injuries to the corn farmers does not necessarily stop with 2015. This slide shows a graph of the corn import nations from 2000 to 2024. It shows the import demands for Japan, Mexico, South Korea, and finally China. As you can see, China did not seek grain import from the outside world until 2007. But as a corn producer, you'll probably have recognized that in 2007, or when corn prices started to dramatically rise, and it was because of the Chinese impact on the available supply of corn globally. At that point, the U.S. was nearly the exclusive provider of Chinese corn. That last peak in the red line on your graph represents the Chinese demand representing the Chinese demand is the point where the Cargill ship was rejected from the Chinese port and China closed themselves to all U.S. corn. The right end of the graph shows China's demand for corn rising inevitably and dramatically. This is because China currently has to feed 1.3 billion people compared to the U.S. with only 0.3 billion people or 300 million people. In addition, the Chinese tastes include an increasing need for high-protein diet of beef, pork, poultry, and mutton, which is a greater demand for livestock feed. It's estimated that by 2018 to 2020, Chinese demand for corn will almost necessitate that they come to the U.S. because the U.S. will be the only nation with enough corn to supply or satisfy China's demand, though it may be in part rather than in total. So we anticipate a potential market loss of China's purchasing of U.S. corn for as long as 2019. By that time, Syngenta will have marketed Viptura from 2012 to 2019, or 7 years. Syngenta has averaged $15 billion in Viptura sales per year since 2012, with a 46% average profit, or $7.2 to $7.5 billion in pure profit per year. For 7 years, that would equal a pure profit of over $50 billion. We estimate evidence to document that the total direct loss will be as high as $5 billion, or about 10 cents of each dollar of profit to Syngenta by its disregard for the injuries to the corn producers or to China. This case is in the discovery phase in 2015, where our side's demanding to see any and all marketing information from Syngenta from around 2009 to probably 2013. That volume of paper may be a semi-trailer or two, which paralegals and attorneys have to comb through blade of grass by blade of grass, looking for express written intent to willfully and wantonly disregard the damages to the U.S. corn producer or to China in order to achieve these kinds of profits. Wanton, willful disregard for the plaintiff's injuries is the standard of proof legally required to obtain punitive damages against Syngenta, usually in the form of double or triple damages. That would leave Syngenta with 70% of their profits instead of 90%, and a long way from the definition of insolvency that would be required of Syngenta in order to file bankruptcy. So far, I've been talking about direct market losses common to all corn producers who had to sell bushels of corn. In a lawsuit where the case has been certified as a class action suit, these are the only damages that the farmers could request, prove, and recover in a court action. Most farmers also suffered more unique individual damages as a consequence of Syngenta interest behavior. Those consequential damages are not permitted to be requested, proven, or recovered in a class action suit, but only the common damages of the whole group. But the individual farmer always has the constitutional right to bring his or own individual suit against Syngenta, where consequential damages can be recovered. When there are thousands of farmers with such a right against a single defendant like Syngenta, the suit is called a mass action rather than a class action. And it's a large mass of individuals bringing individual suits against that single defendant, Syngenta. Examples of the consequential damages from the loss of the commodity price on corn from $8.25 to $3 can be a number of items. One is the farm plan of what to plant where is probably the first thing farmers change. If corn were $8.25, you'd probably plant 100% corn from fence row to fence row. In fact, you'd consider ripping out mama's roses and planting corn stalks around the front porch. At $3 per bushel, farmers plant beans, maybe 80-20 or even 50-50. If at 50-50, you then have an extremely wet year where beans produce very poorly, that's a consequence of the injury to the corn prices by shifts in your corn plant. You may have to prepare fields with additional passes, all at additional expense. You may have additional costs in grain storage or grain transportation because of this loss in corn or because of this change in your corn plant. If you raised seed corn or popcorn, you'll have additional costs or lost opportunity costs as well as consequential losses. Another big item of consequential damage is incurred by corn producers with respect to tenant farmers who are cash renting ground from a landlord. If your rent as a tenant farmer, usually is usually higher at $8.25 than at $3. I have clients whose landlords, very few clients, whose landlords actually lowered the rent when the prices fell to $3, which is a consequential loss to the landlord who does not have direct market loss because they do not sell any corn, and direct market loss is necessary to prove consequential losses. But they have consequential losses because they had to take a drop in their cash rent receipt. And their losses would have to be pled by the tenant farmer as a consequential loss. On the other hand, most farmers did not get a break in cash rent, which means they would be able to plead and request consequential loss for cash rent calculated at $8.25 when the actual price of corn is $3.50 or $4. They should be able to get a consequential award for that difference because they took a hit. Lots of farming costs as well went up when corn was $8.25 a bushel, but they never came down when the price of corn fell $5, all of which are consequential damages. I also have farm clients who are also involved with ag lending telling me that some farmers bought another 80, or they bought a new combine, or they have a new shiny granary when corn was 8 1/4. They are telling me that if prices stay under $4 throughout harvest, some of those farmers are going to have problems with loan payments and with default, which are also a potential consequential damage. One of the factors I analyzed before recommending a group of law firms to my clients was whether they had someone in the group of law firms who was totally focused as a law firm on just the logistics of keeping track of you individual clients as far as establishing proof to your individual consequential damages. It's important to your best interest that that group of law firms is able to do that, because a mass action provides a much more substantial award to you producers than a class action. There are such firms out there, but they're very few and far between. And the law group that I'm going to be recommending to you has one of those firms, but I don't think there is such a firm in this particular state. Some of this state's biggest law firms scared me because I was not sure they could keep track of all the necessary stuff for thousands and thousands of clients at the same time. When you are looking for lawyers to represent you in this type of mass action individual lawsuit, logistics can be just as critical as the trial litigation team or the terms of your attorney contract. In my law group, we have a firm known as Lee & Murphy in Houston, Texas, whose sole focus is mass action logistics. They keep track of you for all the evidence to prove your direct losses and consequential damages. They keep track of the complaint, answer, reply, motions to dismiss, motions on venue, motions on discovery complaints and deadlines, and so forth. They're a team of over 75 paralegals who will contact you regarding your consequential losses with a huge computer paradigm to potential consequential losses in order to jog your memory and then help you identify documentation to prove those losses. There are prior precedent lawsuits for holding international seed grain companies accountable for the damages that their marketing of GMO grains causes to both commodity prices and to farmers who produce those commodities. And comparing those precedents will also highlight the difference between a class action and a mass action suit. The first precedent to talk about is Starling GMO lawsuit of 2002. Starling GMO corn was attacked for being unhealthy for human consumption, and when they marketed the grain, they put restrictions on where the corn could be sold by the farmer. Starling corn could not get the same price other corn got, and Starling was sued for all of this in federal district court. When the law firm filed the suit, they also applied early in the case for class action certification and got it. When the judge granted class action certification, a number of restrictions are imposed on the lawsuit. The law firm must send notice to all the known plaintiffs, usually by way of a postcard, stating that the lawsuit was certified as a class action, that the law firm will represent the class, that the postcard recipient should check the box to join the class and send it back to the law firm, or the recipient can check the box to opt out of the class and send that card back to the law firm. If the recipient did nothing upon receiving the postcard, they were automatically part of the class. The recipient had to mail back the opt-out choice and then file their individual lawsuit within that opt-out period to recover individual losses. That opt-out period was usually 30 days, could possibly be 45 or 60 days, and in this case it was 30 days. In the Starling case, the law firm was given a hard offer of $110 million to settle the suit prior to going to trial. When they computed their attorney fees plus their recovery from the settlement for the cost of the lawsuit, their fees were going to equal $45 million. In all honesty, folks, I, Mike Foster, have never received a $45 million fee, and I bet none of you have ever received a $45 million fee as well, which means both of us would be very, very tempted to quickly latch on to that deal, even though the remaining $65 million was possibly selling the farm clients extremely short. We'd be extremely tempted to take that fee. They took the deal, and individual farmers got $2 per acre. I have clients who were paid with a $2 discount coupon off their next bag of Starling seed corn. Some of them kept those and never as souvenirs rather than turn them in. Other plaintiffs, members, attendees at our town hall meetings reported getting a Visa card or a MasterCard with a few $100s on it. Class action suits are now rather notorious for getting lawyers $45 million and the clients $2 per acre, or $57.82 for a defective auto part and the lawyer's $57 million, or $422.45 for a defective medical device and the attorney's $42 million. My opinion is that the aspect of a class action suit, that aspect of it is why many of you farmers have been so skeptical of this Syngenta lawsuit, to the extent of refusing to sign up or to even attend a town hall meeting to find out what we have to say that makes the suit not only different, but very legitimate and very worth your while. The next court precedent is the Bayer GMO rice case in 2011. Bayer is a subsidiary of Monsanto and developed a GMO rice, but they pursued the same marketing strategy as Syngenta in failing to obtain Chinese approval, and the loss of the Chinese import of rice and the collapse of the rice prices. In this Bayer case, a group of attorneys out of Texas, some of them who are involved with our law group, these attorneys obtained individual representation of rice farmers early in the suit and very effectively resisted the certification of the suit as a class action so that the case would remain a mass action. That meant that farmers had to individually retain attorneys. So Martin Phipps in that group proceeded to conduct town hall meetings throughout the rice-producing states, of which there are only 6 such states in the United States, with Arkansas being the largest rice producer. He acquired about 3,000 rice farmers. The group of attorneys also effectively fought to keep jurisdiction and venue in state courts rather than federal district courts. State court judges are more sensitive to the decisions that upset local constituents because the judges have to seek election and re-election. Federal judges are appointed for life and do not need a concern for constituent disapproval with their decisions. Federal courts are always located in large metropolitan areas like Little Rock, Arkansas, Indianapolis, Indiana, Chicago, Illinois, St. Louis, Missouri, or Kansas City, Missouri. Where the jury pool is a very urban crowd unfamiliar with farming and its economic relationship to the commodities market. Local state attorney court jury pools have a much greater chance of picking individuals who are either from a farming family or who have some relation to a farm background and therefore have a better understanding of the economics of farming and the commodities market. Bayer refused to settle, so they began to try bellwether cases. The attorneys tried 7 cases with a substantial jury verdict in each, such that the average jury verdict, when they started to multiply that times the remaining cases, the results appeared to become very substantial. So in the middle of the 8th trial, Bayer offered $75 million as a settlement, and it was accepted by the rice producers' side of the case. The result was a $362 per acre recovery as compared to the $2 per acre recovery in Starling. About 25%, or about $90 and some change, out of the $362 was consequential damage, and the remaining $270 were the proven direct market losses from the actions of Bayer. The Bayer case is a precedent which demonstrates that mass action results for the farmer are usually superior to class action results. But the problem with mass action is that the compensation is not automatic. the injured farmer needs to retain an attorney by signing an attorney contract to commence that farmer's individual action against Syngenta, which is why I'm talking to you. Please find in your packet the attorney contracts that are in there. The contract is 2 pages, and you'll find one contract that's marked client copy for you to keep, and the other attorney contract is not marked, and that's the one for you to complete on page 2 and provide to us. Now let's take a look at these attorney arrangements, because even though you're being inundated with a half dozen to a dozen different attorney offers, not all these offers are alike. And there's a couple of things I'd like to call your attention to for you to look out for when you're reviewing these different attorney offers. First of all, we're not trying to steal away any clients who have already signed up with another attorney to represent them, because that client stealing would be unethical. We only want a signed contract from an unrepresented corn producer. The next point is that you only want to retain an attorney on a contingent fee arrangement. Rather than trying to pay for an attorney's time on a case like this, which could cost millions in time, a contingent fee arrangement pays the attorney only if he obtains a recovery for the client. But there are about 3 kinds of contingent fee contracts that are very common in the law business. And the key difference is how those contracts handle the expenses of the litigation, which is a different cost from attorney fees. If an attorney has to fly to Seattle to take a deposition, the expense of litigation includes the cost of the attorney's plane ticket, hotel room, and meals, as well as court reporter costs and transcription costs. In the Bayer case, the expenses of litigation were about $30 million, and in Syngenta, they're expected to be about $50 million. I don't think any corn farmers got enough farm to leverage for those kind of costs, especially on an hourly basis. They want a contingent contract. The next thing about contingent contract is that the second type of contract is a 2/3, 1/3 contract, and that's the most common in the business. Here, the attorney fronts those expenses of litigation until settlement, and then being reimbursed for the expense is going to be added to the attorney fee. So the 33 1/3% can easily turn into a 45% or 50% portion from the total settlement. The third type of attorney contract is called a no-risk contract, in which the settlement is divided 60% to the client and 40% to the attorney, like what's on the screen in front of you. Here, the attorneys pay all the expenses of the lawsuit, regardless of whether they win or lose. If you look at the contract that is in your packet, if you pull it out and take a look at it, in paragraph 3, it states that it is a contingent fee contract, but the attorneys pay all the expenses of the lawsuit. In order to do that, the attorneys need someone in the group of law firms who's capable of picking up the $50 million in expenses, because they believe their percentage of participation in the 40% attorney fee will vastly exceed the invested cost. You need a deep pocket who can afford to assume the $50 million loss if there's no recovery. As you can see from paragraph 3 of the attorney contract in front of you, the very distinct advantage I wanted to be able to extend to my clients in referring a law group to represent them in Syngenta was the fact that they would have nothing to lose. And this particular group that's listed in paragraph 3 wanted me to be able to stand in front of you and promise you that very thing, that you would have nothing to lose, that the contract would guarantee that the attorneys would pick up all the expenses of litigation, whether they win or lose the particular suit. This group of law firms wants to be able to assure you that you have nothing to lose by signing that contract that's in front of you and giving it to us. In fact, we've already prepaid the postage on the return envelope in the event that you want to take the packet home, think about it, sign it, and mail it in to us later. In the Syngenta litigation, the master referee has ruled last May that the expense reimbursement to attorneys at settlement time will be 11%. So those individuals who have signed a 33 1/3 contract with attorneys will recover. The attorneys will recover immediately upon settlement an amount equal to 44 1/3 rather than 33 1/3, because 11% reimbursement will be added to the recovery. But that type of contract and that common benefit order doesn't apply to our contract in front of you, because we have already contractually agreed and guaranteed to bear all the expenses as a part of our 40%. So our expenses will stay at 40%. So what will we attorneys do for you for this fee? We will prepare a complaint for recovery of your individual damages from Syngenta. To do that, we need to state the amount of corn that you produced for 2013 and 2014 and maybe 2015, and whatever later years are added to that. That information is available on your FSA 578 forms that you signed and filed. If you look at paragraph 11 on the contract in front of you, it's a power of attorney allowing us to obtain that form, even though that form is available on public record. So our paragraph is really just notice to you that we are going to obtain that form on your behalf. Eventually, we will need to turn your number of tilled acres into actual bushels produced, and the best resource for that is your federal crop insurance report. But if you do not have federal crop insurance, then we eventually will need your actual grain elevator receipts. Grain elevators are regulated by the Interstate Commerce Commission and have to have those available, but only for a limited period of time. So it would be in your best interest as soon as possible to get hard copies of those grain elevator receipts back as far as 2012 or 2013, and just hang on to those hard copies somewhere. Keep them in a shoebox under the bed until our paralegals would call and ask for them. We will also help you define your consequential damages. Lee and Murphy Bank of Paralegals will call you and go through a lengthy list of possible consequential damages, plus whatever potential damages you may have. So feel free when they call you and contact you to ask questions about additional consequential damages. As you find such damages, they will then need you to find documentation that will help prove these losses beyond just your word that you incurred these losses. We will present your claim in the most favorable venue. The master referee has already ruled that he will follow the federal rule of diversity of jurisdiction. That means that if you have a named plaintiff on one side of the V for versus in the middle of the name of the case, and you have a named defendant on the other side of that V, they will determine the state of residence of the defendant, Syngenta, which has a principal place of business in Minnesota, which makes it a resident of Minnesota. If a single plaintiff on the other side of that V is from Minnesota, the venue must stay in Minnesota State Court, and Syngenta cannot force venue into federal district court. But if that plaintiff is not from Minnesota, Syngenta can force jurisdiction into federal district court. If there are multiple plaintiffs, the case will stay in Minnesota if one plaintiff is from Minnesota. So the strategy will to group plaintiffs together so that at least the plaintiff in each group will contain one resident from Minnesota. Thus, Minnesota State Court appears to be the most likely venue that these suits will be filed and brought and tried, so venue seems to have already been decided. We'll also address the motions for certification of class action. Class action has already been applied for in this particular case, and the master referee has announced that he will not decide the issue until the first quarter of 2016. By that time, there could be as many as 25,000 individual suits filed. We have the largest number of those suits, with about 10,000 already, and expecting as many as 15,000. With that many farmers filing, it's expected that Syngenta may not want to bother with a class action, since they already have these individual actions to contend with, and they cannot just dismiss those by having certification of a class action. they may agree to dismiss the move for a class action. And thus, I think our law group has already been involved in this matter and has been effective in protecting the suit. Our law group will also prepare all the arguments and pleadings and motions, and we'll go through all the discovery of documents, followed with depositions of the authors of those documents, with further depositions up the food chain of Syngenta to the top management. And finally, they will prepare and prepare expert witnesses. This case right now is in the early discovery phase of documents, and we'll have to go through the deposition phase before our side would be in a position to even discuss settlement. If settlement is not reached, then the parties will select about a dozen what are called bellwether cases to try. Each side picks about a dozen cases, and then the two parties together will pare that list down by half. They then begin trying cases, very likely in the state courts of Minnesota, and we'll have settlement conferences probably after the first few verdicts are in, and those verdicts are averaged. Here, the trial attorney you pick is a big deal. As for the jury results that are concerned, the attorneys representing you in settlement conference is also a big deal. Unfortunately, Mike Foster, that's me, is not a name that they recognize or fear, much to my chagrin. But some of those names in our legal group, those names listed in paragraph 3 of that current attorney contract in front of you, are recognized names that put fear in the hearts of the Syngenta attorneys. And we will look at who's on that team here in just a second. They usually will start with the biggest groups first in attempting to settle the case in order that Syngenta can limit those settlement costs first. And the smaller groups with a small firm of 5 attorneys may not be given an opportunity to sit down face-to-face at the settlement conference at all, and maybe send emails, letters, or other correspondence to try to settle their cases. It's a big deal and important that, one, you have the right attorney sitting in that settlement conference, and number 2, that we have the biggest group possible, which we have so far, and thus the bigger the group, the better the chances of a better settlement. That also means that having an organization to recruit corn producers from across the Midwest to achieve the biggest group is important to each member of that group, because it helps to achieve a bigger settlement. Syngenta does not have to sit down with all the attorneys at once and share all the settlement results of each group with all the other groups. They can keep those settlement results confidential and not share them, and thus try to cut different deals with different groups. The names on this team of legal firms that I'm representing here was a major deal breaker for my selection of the team. About the time that I was going to choose them, they came to me to herald this lawsuit among farmers. There are about a dozen attorneys like me on this team throughout the Midwestern states of the United States heralding this particular lawsuit. That's important because that means that our plaintiff group will be as large as possible. Right now, it's the largest group that we know of. We have up here on the screen some of the parties. First of all, Justin Demarath is an attorney out of Austin, Texas, who basically ramrods us field attorneys. In other words, his office sets up the town hall meeting schedules, they make the reservations, rent the halls, put together the packets of information and so forth. They kind of organize all that, put out ads, newsletters, direct mail, so forth. It's important that this organization's there because it allows our group to be the largest so that the client gets the best chance of best settlement representation from our group because it's the largest, and Syngenta's going to talk to them first. In addition, we have up here a law firm that I was searching for before making my recommendations to my clients because I felt that, one, if mass action was important and you had to have a logistics law firm that is strictly in charge of keeping track of thousands of you individual clients at once. And that is James Lee of Lee & Murphy. It requires a very large computer paradigm and lots of paralegals to contact and keep track of individual clients, the progress of their case, and the collection of their evidence. It's the element that is missing from many of the large firms in any particular state, the largest firms, because it's hard to find a firm that's strictly devoted to that type of logistics, and it takes a certain kind of technical resource within the firm. They make it possible to have the largest group of farmers as clients, but also to represent each individual professionally and competently at the same time. Lee and Murphy will deal breakers along with these other two attorneys for my clients. In addition, this particular law group, in addition to having a field or an army of attorneys that are doing the recruiting among farm producers and a logistics law firm, we have up here two other members of the group, and you'll see these in paragraph 3 of the contract that's in front of you. And these two are real deal breakers as well. First of all, we have Clayton Clark. And you can see in this particular paragraph 3, that he's a member of Clark Love Hudson Law Firm out of Houston, Texas. Clayton has been a mass litigation attorney for over 40 years. He is well known as a mass action litigation attorney and being extremely wealthy. And we suspect he's probably a multi-billionaire. With a B. His firm evaluates other mass action lawsuits for legal substance of the suit and the litigation team, and then decides whether they want to pick up the expenses of litigation, such as the $50 million in this Syngenta suit. And what they're evaluating is the effectiveness of the team and deciding if their 12% participation out of the 40% the attorneys get will be worth more than the $50 million that they will be investing, and they've decided it's going to be worth a lot more. Clayton is a person that the Syngenta lawyers will respect, if not fear. He will be in the settlement conferences and can easily turn down a multi-million-dollar fee if it's not in your best interest. And his talents are well recognized in the field of mass litigation. You could not ask for stronger, better representation in those negotiations. Then the other part of that team, in my opinion, is Martin Phipps. And in my opinion, he was the main hero of the Bayer case. He's considered to be an expert in GMO grain litigation, and his firm's located in San Antonio, Texas. And they will be handling all the trial of the case, that is, the legal arguments. Martin will also be in our settlement conferences along with Clayton Clark, and these two combined with the support of a logistics firm and a client recruiting firm, in my opinion, are the best opportunity for the best representation and the best recovery for my clients and for any corn producer. Syngenta will try to call the smaller, weaker groups in settlement. Syngenta does not have to sit down with all the attorneys at once. They don't have to settle everything at once. They do not have to disclose the settlement of one group with any other group. In fact, usually those settlements are expressly agreed as being confidential between the groups. And so they will try to deal with the largest group first to limit their expenses. And our group right now, as far as we know, is the largest group. And in the analysis I've just given you, I can explain to you, it explains itself why our group is the largest group, and that makes a big difference in what we're able to achieve for our members as far as a settlement is concerned. The smaller groups, a lot of your personal injury attorneys who are 4 and 5 attorneys in a personal litigation law firm that are great on getting a good return for a broken leg and an auto accident are not necessarily the people you want to do Syngenta mass litigation because of all the different focuses and expertises that are needed. And you need all those players and all those talents to bring it down to a settlement, and this group appears to have done that. We are asking you to sign the contract in front of you, either now or after you've taken it home, and then send it back to us in the enclosed envelope. The purpose of our town hall meetings and this video is to make our group bigger and therefore increase the available leverage that can be applied on your behalf. Tell your friends, neighbors, family members, landlords, and co-op members about us. In a class action, the more plaintiffs will return less for each individual member of the class. But in this mass action, the more farmers just ever increases the overall recovery and the group leverage at settlement time. Let us speak at your next group meeting. At these two websites, you can find information to stay up to date. The Cargill complaint, the Bungie summary dismissal opinion, and some of the master referee decisions are described at these locations. We would expect the only cases that have to go to court are the selected bellwether cases, and before we submit those names, we will contact the individuals to see if they actually want to go to court. If you're begging and pleading not to go to court, we probably will not consider you one of our best cases and would take you off that list, so you will not have to go to court if you don't want to. Guarantee that you will never have to pay money out of your pocket for expenses of this lawsuit. One deadline in this lawsuit is the end of the opt-out period on a certification of class action, but we do not expect that until the first quarter of 2016. A more relevant deadline is the statute of limitations, but we will not know what that date is until farmers have filed too late and Syngenta comes back with a motion to dismiss for breaching the statute of limitations. The two sides will then argue, one, what kind of suit is this? Since there's a difference in the time limits applied to different types of suits, whether they're a contract or a tort or some sort of intentional injury, we think there's a 60 to 70% chance that the case will be considered a tort claim with a 2-year statute of limitations by most judges, and that would be decided by the master referee. He's going to look for something that's a clear, simple mark to delineate when the statute begins, what type of statute it is. The second issue with statute of limitations that the two sides will argue is when the time began to run, with Syngenta saying it started and ran many years ago, and our side will argue that it just started yesterday. We think the 60 to 70% chance is that the judge will want a simple, common sense line drawn, and that'll be when the Cargill ship was turned away from the Chinese port in November of 2013. So my opinion is that you can take some time to think about which contract you want to sign, but that decision should not be delayed past November of this year, 2015, or your complaint will be running the risk of being included in that motion to dismiss that Syngenta will file because this case was filed after the statute of limitations had run. All the information that you give us is attorney-client privileged. We are all regulated by different state bar organizations on how we store that information so that it's not available online for hacking. So all the information is subject to those regulations and protected. We think that watching this video or attending a town hall meeting will take as much time as anything that you will be involved in with this case. After signing a contract with us, you'll be contacted by the paralegals at Lee & Murphy for additional information from time to time that would become evidence. Those contacts will take a few minutes each, with probably the contact dealing with consequential damages taking as long as 10 or 15 minutes. But that'll be the most time that you'll have to devote to this particular case. Mass action suits average 4 years and 10 months to settle. Cargill started in October of 2014, so that comes out to somewhere in 2019. Settlement could come sooner, or it could come later than that. Our side's in the middle of discovery, which will be followed by about a year of depositions. The evidence we will be looking for is documentation of intent warranting an award of punitive damages for 2 or 3 times the rest of the damages. which is a substantial difference that we cannot settle until we either have or do not have that evidence. So I think there's a 90% chance we cannot settle this Syngenta corn litigation before the end of 2016. My opinion is that there's a 50-50 chance of settlement in 2017 and better than 80% chance of settlement in 2018 or later. What can accelerate those estimates is that Monsanto has made offers to buy out Syngenta, but the Federal Trade Commission told Monsanto in May that they would not approve that because Monsanto would have an international monopoly on seed grain. Then the Wall Street Journal reported in June of 2015 that Monsanto was making a huge offer to the shareholders of Syngenta to buy their stock. But remember, there are only two shareholders, Novartis and Seneca. And according to the Wall Street Journal, they are offering hundreds of billions of dollars to these two shareholders. For Monsanto to close the buyout of Syngenta, they would either have to agree to accept the hit for the liability for Viptera or settle that liability before closing the sale, which we're not ready to do at any time soon, or put up an actuarial reserve of many billions, which they will find very distasteful. Syngenta's profits have been so large, as discussed previously, from the sale of Viptera that they would not be able to meet the definition of insolvency necessary to file for bankruptcy, at least not without some sort of transfers and conveyances that would possibly smack of being fraudulent. That extreme profitability will actually fuel more research and development in genetically modified grains, not less. Perhaps the better question to ask after reading this particular slide is, what do you have to lose by signing a contract with us? We don't think there's anything to lose, and we've really made great efforts to make that clear to you. We think that this Syngenta litigation not only is one of the best grain cases to come along, but it offers the tremendous opportunity to set a standard for seed companies that they cannot just simply run right over people and pursue the sale of their GMO grain without any regard for anyone else. This will set the expense of such disregard at a high enough level, or so we hope, to deter such wanton, willful behavior regarding other individuals who are hurt by their actions in the future.